your tenancy agreement doesn't say this, your landlord could be breaking the law in 2026. The Renters' Right Act 2025 changes what landlords must clearly tell tenants in writing. Let's break down the key changes every tenancy agreement must include in plain English. Firstly, your rental agreement must clearly state how much rent that you pay and when it's due, so there's no surprises and no guesswork. And if your landlord wants to increase the rent, then they must serve a Section 13 notice. No notice means no lawful rent increase. Next, the bills. The agreement must say whether utilities, council tax, TV licence or communication services are included in your rent. If they're not included, it must explain how you'll pay them, when they're due, or how you'll be notified. Transparency is the rule. If you pay a deposit, the agreement must state the amount taken. If it doesn't, it doesn't need to say which scheme is used, but it must clearly state how much was taken. Your tenancy must also say how much notice you need to give to leave. Normally that's 2 months, but it can be shorter if the landlord agrees. Now, this is the big thing. Under the Housing Act 1988, landlords usually can't end an assured tenancy agreement without a court order. And to get that order, they must normally serve a Section 8 notice using the correct form and legal grounds. And the notice period, that depends on the grounds that they use. If you rent or you're a landlord, this stuff matters. Follow for more plain English Renters' Right Act information.